Hello, hello. Thank you for hopping on for this month's Arts Counsel Texas Lunch and Learn. Very excited to wrap up the third of our three-part copyright extravaganza that we've done over the last 3 months. We're going to give it just a minute, let a few more people pop in, and then we're going to get started. All right. Well, again, thank you for coming to this month's Arts Counsel Texas Lunch and Learn. And my name's Tom Madry. I'm an attorney over at Madry PLLC, and we're an art law firm doing a lot of work in the visual arts, certainly with painters and sculptors and photographers. And I'm here with Michael Heinlein from Thompson Knight. And Michael, why don't you tell us a little bit about Arts Counsel Texas?
Arts Counsel Texas is a nonprofit that we started a few years ago, and both Tom and I started out our careers more in the art world than in the legal world, and we had, at least in my case, a midlife crisis, and turned out I went to law school. And one of the things that I learned as a lawyer is that artists and people in the creative community are both intimidated by and know very little about art, and that people in the legal community, let me put that back. People in the creative community know a lot about art and little about the law and business, and people in the legal community know almost nothing about art. And we kind of thought that was a shame. And Arts Counsel Texas is, the goal is to go out there and help creatives with their works by giving them an understanding about legal and business issues, and to help lawyers learn about the art world and the art market, and the ultimate goal being to help bring the two communities together so that each is a little bit stronger and the world is a better place.
That's a goal that we certainly hope to achieve, and today we're going to do it through copyright registration. Let me thank Cedars Union, where if there weren't a pandemic, we would be doing this live, as we have for many years now. And so let me turn over to Adrian from the Cedars Union and tell you a little bit about them and some of the things that they have coming up.
Hey, so I work at the Cedars Union, which is a nonprofit art incubator in the Cedars neighborhood just south of downtown Dallas. I know we have a lot of familiar names up here, so hello to everyone who knows the Cedars Union well. But we're a nonprofit that's dedicated to supporting emerging and local artists in the city through affordable studio space, which is comes in both private spaces and a community membership that's almost like joining like an art gym of sorts. You pay a monthly fee and you have access to shared workspaces and tools. But we're also really passionate about entrepreneurial training in the arts. So kind of like Michael had talked about with Arts Counsel Texas, we very much realize that a lot of artists aren't equipped with business acumen. So that's why partnerships like Arts Counsel Texas is so important to us, because we like to help connect those dots for everybody. We do have a couple things coming up. So next week, we have a webinar from Daryl Radcliffe, and Daryl Radcliffe is going to talk about artist grants. So this is going to be a really good one. We've had a lot of requests for a webinar like this. Daryl's received a long list of grants from local and national grantors for different projects he's done. So this is a really great way to learn about his process for finding grants that meet his projects and effectively applying and getting them. We also have another Arts Council program next week, which is a legal clinic. So if you have any specific questions about your art, this clinic, it's like a call-in kind of thing. You register for a time slot and you can speak to a lawyer one-on-one about your visual art or creative art queries. And we also have a fundraising auction coming up. So check out thecedarsunion.org, and I will stop talking.
Well, thank you, Adrian. And I'm excited about the auction. I'm excited about next week's legal clinic. That webinar sounds great. I've gotten to speak with Daryl a few times on other projects, and that's going to be really wonderful. Remember, our Lunch and Learns are the second Wednesday of each month, which means we have one more this year. It's going to be in December. And this is our kind of open forum. Bring any questions you have about anything we've discussed. Over this year, we've talked about, obviously, copyright and contracts, rights of publicity, rights of privacy. I think we, maybe even before the pandemic, might have done some First Amendment stuff, although I forget, that seems forever ago. And
Another world.
Another world, absolutely. So bring your questions. That will be December 9th for our last Lunch and Learn of the year. So I'm going to turn it over to Michael, who's going to do a quick introduction, and then we are going to go do some copyright registrations together right on the screen. We're going to do a lot of different stuff, and I'm going to fly through things. Remember, these sessions are recorded. After you attend, you'll get a link where you can come back and watch it over again. It's a real opportunity to essentially sit with a lawyer and do a copyright registration. And so that's our goal today, is to get everyone comfortable with the registration process. So I am going to turn it on over to Michael, who will get us started.
Well, let's hope so. I'm going to see if I can figure out how to share the screen, and hope this works. Find all my buttons. And maybe show a slideshow. And how about let us, we practiced this. I'm going to try one more time. How's that? All right. So what I want to start with is just, yes.
Michael, I'll jump in. I'm sorry, I was muted. I forgot about it. While we're getting that going, if you have any questions, please put them in the questions tab. That's over on the right-hand side. You can also chat with each other, but go ahead and put them in the questions tab there. And that will make sure that we get to answer them today. All right, you're on.
So what I want to do, just to start off, is since this is about copyright registration, I want to start with a really short review of some of the things that we talked about in the last couple of Lunch and Learns. The first is that just to remind you all that if you create an original work of authorship that's fixed in a tangible medium, as soon as the work is fixed in a tangible medium, you have a copyright. And to remind you, original means that something is a little bit new. For our purposes today, a work of authorship could be a painting or a photograph or a sculpture, a poem, a song, anything like a work of art. And as soon as that work is fixed in a tangible medium, that means that it becomes, in some sense, a physical work as opposed to just something that merely happened, like if you sang a song for the first time in the shower without recording it. If it's recorded, if it becomes physical somehow, the work is automatically copyrighted. For example, and here.
Oh, Michael, I don't know.
It's not my show, it's just my screen. Okay, let's see.
Yeah, let's.
For example, I think we can get by.
Hey, and yeah, you just go ahead. Yeah.
So this picture on the right is a photograph that I took, and as soon as I clicked the camera, click the shutter on the camera, it was fixed in a tangible medium, and I had a copyright in it. So that immediately I had a copyright. So that kind of begs the question, why bother registering it? If I've got the copyright, why do I want to bother with the time, the hassle, and the money of getting it registered? Well, as you can kind of see here, well, you can't yet. In this case, I want to get this registered fairly quickly because, as Adrian said, there is an auction coming up and the works are going to be put online. So this photograph that I took is going to be visible to the world, basically. So it's going to be one of the things that's put up at this Cedars Union auction. And one of the things that is associated with my image is a little poem that I wrote, which says, "Crystalline whiskey, 2 drams of Lefroy in a Waterford tumbler." Okay, so what this means is that there's a chance, I know it's a very slim chance, but there's a chance that somebody from Lefroy might see this and like it so much that they want to incorporate it into one of their ads. And it might look like something like this. So if I find out that Lefroy is using my image in an ad without my permission, what can I do? Well, I could write a cease and desist letter. I can write a letter demanding that they pay me a license fee. But what if, as probably normally happens, they either ignore me or they just outright say, forget it, we're going to use your image. How can I enforce my rights as a copyright holder? Well, in the first place, I can't sue them because I haven't registered it yet. To be able to sue somebody to enforce your copyrights, you have to have registered it. Now, I can do that after the fact. If after I've seen this, I can register it and then go ahead and file a suit. And since I can, it begs the question again, why bother? Why not just wait until I see that this has happened? Well, there are 2 reasons. Lawsuits are very expensive, and I didn't lose a whole lot of money. It literally costs tens of thousands of dollars, and quite often, and maybe usually hundreds of thousands of dollars to bring a copyright lawsuit. And I'd only likely to be entitled to recover the amount that I lost, which is usually just license fees, which is probably several hundred, or maybe if I'm lucky, a few $1,000s. So even if I win, I'm going to be out tens of thousands of dollars. And that is why you bother registering it. Copyright registration before somebody steals it. So if you register your copyright before it is stolen, you get the chance to get attorney's fees and what are called statutory damages. Attorney's fees means that if it's registered, if I register it today and they steal it tomorrow, if it gets registered today and it's stolen tomorrow, and I bring a lawsuit and I win, then it's a good chance that they will have to pay me back my attorney's fees as well as any kind of damages. And that's, remember, we said that a lawsuit costs tens of thousands of dollars. I'd get that back. But even better than that, I can get something called statutory damages. So I get more than just the license fee that I lost. I get what are called statutory damages, which are up to $150,000 last time I looked. And so I could get my attorney's fees plus a whole lot more money if I had taken the time and spent a few dollars, we're going to find out, necessary to get it registered right away. And so I think that those are 2 really, really good. If you value your copyright and you want to be able to enforce it, these are 2 ways that allow you to do it. Because in all honesty, your copyright is close to worthless if it's not registered. You have it, but the only way you can use it and effectively use it if it's registered. And so what we're going to do today is Tom is going to show us how easy it is to do that. And one of the images that he's going to register is, in fact, this very image right here. So I'm much better at turning off screen share than turning it on. So I'm going to turn it back to Tom right now. Go for it.
Well, thank you. And yeah, we are going to hop into the Copyright Office website in just a second. I want to run through just a few things so that you have them as we move forward. Okay, now my turn to do stuff. All right.
Show off.
Yeah, well, I spend all day here, right? So we're going to talk about registration. Some of this is just the history of the U.S. Copyright Office and what they do. But one of the most important things they do is registration and recording of all the copyrights that are registered, right? As Michael said, you don't have to register your copyright to have the copyright protection. It's a really, really good idea. I'm going to skip through some of this that Michael already talked about, the actual damages and the statutory damages, but be aware that this is a PDF, and we'll put a link to this PDF in the chat so that you can have this for the future. So on the form that many of you will be using as visual artists, things like advertisements and cartoons and illustrations and logos and photographs and paintings and sculptures, this is the type of category that you will register your works in. We're going to see a drop-down menu in a second that shows which works you register where. When you file the application, you go to copyright.gov, and then you go click on register, and it takes you to a place called the Electronic Copyright Office. And at the Electronic Copyright Office, you then fill out all this information. And you start with the name and the address of the claimant, whether it's a work made for hire, the title of work, the year of creation, whether it's published or unpublished. And then if it's all copyrightable, you get a certificate. So real briefly, because it's going to come up, this is one of the hardest questions in copyright. And I'm going to address it, and I've addressed it a few times, so I'm going to address it again. And I'm going to end up by saying that this is still a big gray area, and the Copyright Office gives us some guidance and then stops. And courts give us some guidance and then stop. So the Copyright Office says, the distribution of copies or phonorecords of a work to the public by sale or other transfer of ownership, or by rental, lease, or lending. That's published. They go on to say, the offering to distribute copies or phonorecords to a group of persons for purposes of further distribution, public performance, or public display constitutes publication. A public performance or display of a work does not itself constitute publication, right? Okay, tricky stuff. So let me kind of, there's one definition there right below that, and it says, generally publication occurs on the date on which copies of the work are first made available to the public. Unpublished works are works that have not been distributed in any manner. That's different though than they don't exist yet, right? The main consideration, and Michael may have 2 cents on it, but the main consideration is that whether copies are released to the public or made available to the public by authorization of the copyright owner. Publicly available does not always mean published, right? Works that are seen but are not distributed are classified as unpublished. When a court looks at this, they look at the specific intent of the publicly to make copies publicly available. And the last point that I think is important is when content is available to consumers, even without the availability of copies, it's possible the work will be considered published. The question that we get all the time is social media publication? Well, it's a little tricky, right? Because you're putting out your work into the world. Is it available to be copied? Well, I guess it is. Are you aware of that? Is it going to the general public? But remember, looking at the definition, the offering to distribute copies or phonorecords to a group of persons for further distribution, public performance, or public display. There's this whole issue of when something is published, right? And is social media publication? We've talked to people at the Copyright Office about this. There is still a divide that you might find on this, but if you are a professional artist and you're putting your work on your Instagram or on your website, and the purpose of that is to get people to buy your work, then I would say that's publication. If you put something on your personal social media accounts, you might be able to argue that's not publication, right? That's still a very gray area, okay? But it matters because you have to pick the right form. So here are some quick common questions, and we're about to jump into it. My work is hanging in a gallery. Okay, so the Copyright Office says simply exhibiting one copy of your work in a gallery is not published unless it's exhibited through another party, which then offers your work up for sale. Also, if your image is in a gallery and then it appears on the cover of the show catalog and that is turned into an advertisement, now we're probably very likely talking that that work has been published. Whereas if it's just hanging, then it's not published, is what the Copyright Office says. Can you register your work with the USCO if some things are published and some are not? You have to, yes, you can, but you have to do it in separate applications. You can't do it on the same application. Is a work published if it's on my website? So my view, and I'm a little more protective because of the benefits you get, but probably if it's in a public area of the website is my 2 cents on it. If you're a professional artist, right? You can and should register your unpublished work with the Copyright Office before uploading the images to your website, if at all possible, and putting it on social media, and then you get around this whole problem. Doing things when they're unpublished, like we're going to do today, is the way to go. If your work is delivered to a client, even if nothing is ever printed or published, does that mean it's been published? Another tricky situation. Your paperwork, your contracts and things can address this, but if you are giving something to a client and the client never uses it, it's a plausible argument that you gave it to the client for purposes of further distribution, but it's also a plausible argument that it was never made available to the public. Let's say your contract says, here are the ones you get to choose from, but you have to tell me before you print it, then maybe that's unpublished. Okay, I hope you're adequately confused about this particular issue. So I'm going to talk about artwork and I'm going to talk about photography. And the reason I'm talking about the two differently is because they're treated differently at the Copyright Office. You can't register a group of published artwork. If your artwork is published, if you consider that your artwork is published, then you have to register the work individually. Now, that is different than photographs. You can register a group of published photographs. Can't register a group of published artwork. You can, however, register a group of unpublished works. You get to register up to 10 works. First, you have to determine whether it's published or unpublished and use the right form, right? But no more than 10 works on your group registration for unpublished artworks, okay? So you can have 10 paintings, 10 drawings, 10 poems, right? 10 anything for your unpublished work. All of that work has to be created by the same author or co-authors, and the author and the claimant, which we're about to talk about, must be the same person or organization. You have to have a separate title for each work, you have to upload a digital copy for each work, and your file names must match the titles. So that is for doing up to 10 unpublished works. That's called a group registration of unpublished works, okay? Now, if you're a photographer, you get special rules. You can do group registration for photographs, up to 750 photographs in a registration. You have one for published and one for unpublished. We are going to be registering some photographs today, and so I'm going to be using this new thing which they introduced to make photographers' lives harder, this spreadsheet that they want you to use. And I'm going to walk through how to use the spreadsheet as well. Now, if you are doing a group registration of your paintings, you don't have to have a spreadsheet. But if you're doing any kind of group registration of photographs, you do have to have a spreadsheet. We're going to go into all of that in a moment. So here are the steps. You go to the electronic copyright office, you sign up for an account if you don't have one, you log in and you see the homepage, and for example, and I'll show you exactly where this is, you can register a group of photographs. Then you start the registration, choose the type of group, and confirm that everything you just said agrees. You create a title, you add individual titles, blah, 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 because we're about to do the thing. So let's do the thing. Here we go. Now, I am going to share another screen. Okay, can y'all see that? I hope so. Let us know. Let us know in the questions or the chat if you have any trouble. And Michael, while I am running through this, if you see some questions in there that you have answers to, or then I'll stop and we'll do some questions at the end. Okay.
All right. Well, there's one right now that has. I don't know if this is the one that you addressed your publication answer to. The question was whether a commissioned work of public art that's on display outside for the community to look at is published. And my initial thought is yes, that would be published because it was commissioned. Somebody paid you for it. You created it, and now it's on display. What do you think?
Yeah, that's a super interesting one because since it was commissioned, but simply a commission, if it were to be in a private place, that might not necessarily be published. If it's in a public place, does that mean it's published? Here's where I would say, is that sculpture, is it on the website of the city? Is it in a pamphlet? Is it all that other stuff? Then I might say it's published. If it is in multiple locations and your client is using it in multiple ways. I think there's a plausible argument that if it's simply been commissioned and paid for and exists out in the world, that it's unpublished. So you have two lawyers who both do this for a living, who gave you two different answers on the exact same thing.
Well, yours was a little bit more nuanced, and I think I would go with you on that. That certainly just because a work is commissioned doesn't mean that it's published. And I think it does make a difference how it is being displayed potentially after the fact here. So.
Yeah, and I see Sarah continued and said, yes, it's on the website, it's marketed. At that point, I think it's published work. All right. So first thing we're going to do is we're going to register a group of photographs, and I'm going to 90% of registering anything on the copyright website is exactly the same. The 10% difference, whether it's artwork or jewelry design or choreography or music, the difference is just in that little 10% window. So everything that I'm going to show you, you might say, hey, I'm a writer. Hey, I do all these other things. No big deal. Okay. We're going to show you exactly what you need to look at. So this is the Electronic Copyright Office. And the first thing you do is you look over on the left-hand side. And on the left-hand side, it says register a work. Okay, register a work. There's the standard application, which is used from time to time. But down here are other registration options. Here you can register certain groups of published works. And if we click on that, we'll see that those groups are 3 months of issues from the same serial publication, 1 month of issues from a newspaper or newsletter, a group of contributions that are published in periodicals, and at least 2 and up to 50 short online literary works. You'll notice that is a very narrow group of things. Most of you who come to Lunch and Learns and the work you do, that does not apply to you. Register a group of photographs, and we're going to come back to that. Register a group of unpublished works, and this is the one I was mentioning. So here's the eligibility criteria. All the works must be unpublished. You may submit no more than 10 works, 10 poems, or 8 drawings, or 4 songs. You must submit the same types of work, such as a group of songs or group of drawings. All the works must be created by the same author or co-authors, and the author and claimant for each work must be the same person. You have to provide a separate title, and you have to upload your digital copy. 10 at a time. If you're a painter, you're a sculptor, this is where you would click to do up to 10 at a time. Register one work by one author. Well, let's say you want to have a registration for one thing, one painting, one photograph, one sculpture. You can use this application and you pay less money, okay, and than the group application, and you just do one here at a time, okay. All right, so and then there's all this other stuff, and most of this you'll never mess with. But where we're going to start today is on registering a group of photographs, because remember, all the questions that we're going to go through are pretty much the same, and I'm going to identify where they're different. After we do this, we're going to register a book in which these photographs appear. It's a book of poetry. All of the work today we're registering is actually Michael's work, so we are thrilled to do that. I am going to go ahead and click on Register Group of Photographs. When I do that, it's going to ask me if I meet the eligibility criteria. So these applications can be used to register a group of photographs or a group of unpublished photographs. And then all you do is put in the information, pay the fee, and upload your work. Let's start. First question, type of group. Please select a type of group. So these are unpublished photographs. When you select that, it's going to tell you, what does all this mean? If you're going to use this, all the photographs have to be unpublished, created by the same author, and owned by the same copyright claimant. When we're done, we're going to upload our work. You have to give the Copyright Office what's known as a deposit copy. Your images have to be in JPEG, GIF, or TIFF format, but you're strongly encouraged to upload all the photos in a zip file, which we are going to do, okay? Then it says you must submit a sequentially numbered list. Remember, this is for photographs only, okay? And I'm going to show you how to fill that out. So I agree that this applies to me. Continue. The first thing we do is we give the group of work a title, right? So we're going to say new title, and Michael, I think the title here is, let me pull up to register. There we go. Title here is going to be Ignorant Eyes. Is that correct?
Yes.
Okay. And the year of completion was 2020, right?
Correct.
And the numbers of photos in the group, there are 41. So I'm going to click on 41. This goes down to 750, remember? Okay.
And so since just heard your whole spiel about published and unpublished, I just want to make something here. Let's make it real. Now I'm your client and you're my lawyer that's doing this. And I heard all this and I got a question for you. So I make a picture. And then at some point, and as soon as I made it, like I learned, I have a copyright in it. And then at some point, I do some edits to it, and I change a little bit. Maybe I use Lightroom or Photoshop to change the exposure, or I crop it, or I do something different. And let's say I published the original, but now I've got a new one that is edited. Is that edited version? How would you classify the edited version if I wanted to get a copyright in the edited version?
So you have your copyright in the edited version, and under this idea of derivative works. And you, remember, one of your main copyright rights that you own is the right to create derivative works from your original works. So if you have an unpublished, if you register your work and then later on you alter it or modify it in some way that is not so far off base from the original, you do not have to get a separate copyright in that work. Now, I say that, but you might want to get a separate copyright. So let's say you have an image, and then 2 years later, you're approached by a client who wants to buy it for some reason, and they want to change it all up and do all this crazy stuff. You may want to register it again because you think now it's been changed enough and it's going to be used in a slightly different way. But do you have to? Absolutely not. Changing, cropping it, changing things, that is not going to result in a new image to be copyrighted, but a version of the original image. Michael, do you agree with me?
I think I agree with you, but I'm wondering because one of the 41 works, a prior version of one of the 41 works was published, but not the version that I sent you yesterday. And so, can we still call them all unpublished?
So there, we would want to, if we can, remember you get to make these arguments, right? And so here you can say the version that was created now is a new work, and it's been, if you remember what we were talking about last month, transformed in some way. And so now you can say, even though this is from the original, it is a new work. That is something that I would feel comfortable with doing as well. Now, you could pull it out of this registration and do it the other way, and that's absolutely fine as well. Okay. So I would say to the client, would you like to pull it out of this registration, or would you like to register it again as a new work?
Well, I'm just trying to make this real because, as a lawyer, your clients are always coming at the last minute and trying to make your life more difficult. So
yeah. So I tell you what I would say is, if we know the number of this one, I would pull it out. If it's truly what might be considered derivative work that was previously created, we can pull it out.
Okay.
Yeah. So
do that when the time comes.
Okay. Well, so there's not going to be 41. There's going to be 40, right?
Yes.
Perfect. All right. Okay.
And again, I'm just trying to make this real.
Hey, the other thing that we're making real is that the copyright website is terrible. So you will get errors. And so now we're registering things. We entered our title. Now, if you look over here on the left, you have all these different titles, right? All these different options. It's going to just walk you down the list of things. And we're going to end up writing things over and over and over again. So now I'm going to say continue. And we're going to put in Michael's information because Michael is the author. So the first question it asks you is about the author. You can give the individual's name or the organization if it's a work made for hire, or both. You can't do both. You have to do a work made for hire with the organization or the individual. So here, this is the individual. And Michael, is it J period and then middle name, Michael, or all in the first name field? How would you do that?
I guess James Michael Heinlein.
Okay. And when I put in his name and he's a citizen and he's here in the US, you only have to do the stuff that start. You don't need to put the year of birth and the year of death, and you don't need to check anonymous or use a pseudonym if you don't want to do that. And I recommend generally that you don't. But notice this box here. Is the author's contribution a work made for hire? Now remember, we talked about work made for hire in the previous months, but essentially, if you are an employee operating in the course and scope of your employment and you create copyrighted works, you don't own that copyright. Your employer owns the copyright, okay? And so if you think you're a work made for hire, if you know you are, then you would check this box, and the copyright owner, the author, or the claimant, which we'll talk about, will be the company. If I select work made for hire, all these things have help to the right-hand side. And if I click that, it gives me a page on what that is, okay? And then this tells you who owns what, okay? Now, work made for hire, we're going to say no, okay? So we put in the name and where he lives, and then we say continue. Now, the author and the claimant, please identify the copyright claimant. The author is the original copyright claimant, but the claimant can also be a person or organization if you have transferred your copyright. So if you've done a job and you've transferred your copyright as part of your contract, maybe that's a sculpture that's commissioned or a painting or a photograph, then you would put that the author is not the claimant, that there's a new person who is the recipient of the transfer. But if you do that, you have to have a transfer statement. And that transfer statement tells you what you need to have. So again, click on that, and it talks about what needs to be in the transfer statement. Okay. Here, the claimant is the same as the author. So we're going to say a new claimant, and guess what? Here, we have to add in the address, and let's all not go visit Michael. And then it says, if any claimant is not an author, you must include a transfer statement showing how the claimant obtained the copyright. No, claimant's the author. We'll hit save. Now notice we have one claimant down here. Great, continue. This screen is also going to be Michael's information. This is the rights and permissions information. If you want to designate someone to be contacted, if they want to use your work, then you can put in the information here. I recommend you put in the information here. For a lot of my clients, they'll put me in here so that if someone has a question, they can call me about, licensing Michael's works, right? So this field is public information. That means if you don't want the world to know what's in this screen, you can put a private address, or you don't have to put anything, okay? So Michael, would you like me to put your name and email down, which is generally what I recommend, in this field?
Yes, please.
All right. And I know there's probably questions coming in on possibly each of these screens. I'm not super paying attention right now. When I get to a stopping point, we'll go back and we'll answer all these questions. Now, if you were doing this for yourself and you were doing lots of different applications, when you set up your account, you put in all your own information, and then all you check is this box, add me, and it puts in your information. We're obviously not going to do that, but I want to show you. That way you don't have to retype everything every time, right? Okay, continue.
Except you want to get rid of all that.
Yeah. I'm sorry, I didn't see it pop in there. Yeah, I don't want to be contacted with all the people that are going to buy all your work. Next. Oh gosh, fifth screen in a row. Actually, fifth screen in a row. Correspondent. Who should the Copyright Office talk to if it has a question? Guess what? It's going to be Michael. So, email.
So if this were real and you were my lawyer doing this, would I want them to contact you, or would I want them to contact me?
So it honestly depends on the size of the organization and what your arrangement is with your lawyer, right? Some of my organizations are big enough that they are doing this, and so they feel comfortable with that. A lot of times I'll be listed here if I'm working with individual artists or small studios or groups of artists, right? So you could add me in here, but for this application, we will add Michael's name in here. Great. Continue. Oh my gosh, sixth screen. Who am I going to mail the certificate to? Guess what? I'm going to mail it to Michael. Okay, continue. Special handling. Do we need to do special handling? Well, first thing to know is that it costs you an extra $800. So don't do it unless you need it. Why would you need it? Only 3 reasons, pretty much. Pending or prospective litigation, customs matters, contract or publishing deadlines. We are not, I'm going to presume, Michael, not going to do any special handling.
No, please
Now,
no.
now, it is important to note, you submit this application, when does the copyright become effective? Well, if your copyright is registered and you're issued a certificate, you're protected back to the date of your original registration, okay? So it might take the Copyright Office months to get you something, but that's okay, because when you get something, it will be backdated. Note, however, that if you want to go to court, like Michael said, you have to have that certificate in your hand. And you can only get that certificate in your hand quickly if you check this box that says pending or prospective litigation. All right. This application must be certified by the author, copyright claimant, owner of exclusive rights, or by the authorized agent of any of the proceeding. I am going to operate on the fact that, Michael, am I your authorized agent here?
Yes.
All right, so I'm going to type in my name. And then it's asking for the file name of the required numbered list of photographs. So here is one of the only differences between the application that you will provide and this one. So now I'm going to show you how to quickly do this file name. Michael, do we remember which what number we want to take out of this group?
33.
Okay, perfect. So I'm going to pull out.
I believe it's hanging in your office, or it once was.
It what? Oh, it is. Okay, good. All right. All right. I'm going to pull out 33. And I'm going to start something else that I'm going to show you in a second. And I'm not going to change any of the file names. Give me 1 second here. Okay, perfect. So now I'm going to switch my screen, and I'm going to show you a group registration template for unpublished images. And then we're all going to collectively agree that this is an annoying thing to have to do. Give me 1 moment. All right, I think everyone can see that. Let me try to make it a little bigger here. Okay, so the first thing we do, this is the template from the Copyright Office. The first thing it asks for is your case number, and your case number is at the top of every screen that we just looked at, and I'll show it to you when we get there. So I'm going to insert the case number here. It says insert the case number there. That's your case number. Okay, perfect. In fact, what I normally like to do is this. Oh, I got an extra space in there. There we go. And it turns green when you get it right. So good job, we got it right. Now, column 1 is photograph number. Column 2 is title of photograph. Column 3 is file name of photograph. And then it tells you over here if you have any missing information. It's going to be super simple. I'm going to pull up on my computer kind of, file system, a list of all the photographs. And I removed the one that we talked about. So there's 40 selected. I'm going to copy those. I'm going to stick my mouse right here in photograph number 1, and I'm going to paste. And now we see we have this one weirdly being bold and italicized, but we have all of these, and you'll notice we go all the way down to 40, and we took out 33. Now look, it says, are you missing any information? Yes, I'm missing the file name for the photo. Now, over here, I just copied and pasted the same thing. And now we have everything looks green, everything's good to go. Now you might say to me, should the titles be the same as the file names? And my answer to you is, why not? This is identifiable enough. Your titles don't have to be anything special. You can make them special. Here, I don't have any problem with the fact that it has .jpg at the end. This is something that just makes your life more simple than doing it the other way. Okay, so now we have this whole thing kind of set up, right? But I want to look at one other thing. We have to save this, okay? We have to save this in the right way. How do we save it? We save it by using, I don't know if y'all can see that. You can't, but you're going to see it in a second. We save this by using the name of the group and then the case number. All right, and grab that again. And this has to be called this, and it has to be done in this way, okay? And so I'm going to save that as an Excel sheet in my thing to register. Now notice at the top, I put the name of the group, case number, and then that. That's how you name this sheet. We're done.
So where did you get the template to start with?
I will show you that when we switch back to the copyright office. Good question. Now, before I close this, I'm doing one more thing. And this is only for photographs, so be aware. I'm going to select everything in this green column. All these numbers, which look exactly like the other numbers with one difference. There's a comma after the names. Why am I doing this? I'm about to show you. So I select those and copy. Now I'm done with this sheet. I'm going to save and close. And then I'm going to pop back over to the Copyright Office window. Perfect. So the next thing I'm going to do, okay, the next thing I'm going to do, and you get to decide in what order you want to do this. Remember, I told you that the thing for photographs is a little bit different. The reason I selected and copied all those titles in the very last step there is because we have given a title to the group, but we have not indicated on the application the titles to the individual photographs if we want those to appear on the certificate. It's generally a good idea, but what you have to do is fill out that spreadsheet first. And then, and this is tricky, you have to go back to the titles field up here on the left. Here is the title of the work being registered, the group. I click New, and we get a whole different screen that says enter file names for individual photographs in the group. And then this is where I paste all the things. Let me paste it. I guess I didn't copy it, right? But give me a second. I'm going to show you why we do this. Now, all of these will appear on the actual copyright certificate. If I didn't do that, then the only thing that would appear is the name of the group. This is beneficial, but not required. We tend to do it now, and you'll notice that it just kind of sticks everything together, but that's okay because there are commas in there. And then again, you pick 40 photographs that were entered on this screen. Save. Now we're done. Notice that the title of the work being registered is this. The contents title is that. This little piece right here, even a lot of copyright lawyers who do this daily don't know this. This is something that if you do this, you'll be better off. And so this is on these group titles. So now I'm going to save that. I get my check mark. I go back to certification. I certify I'm the guy, Thomas Madry, the file name of the thing, copy, paste right there. If I have an internal tracking number, great, and I say continue. Here you get to check everything over. I think what we really need to check is that everything is spelled right and everything looks good. And I think you were checking as we went, Michael, right?
Yep, you got my name right.
Pretty good. Okay. So now we say add to cart because they want their money, but we're not done yet. Here is the cart. For a group of unpublished photographs, it costs $55. So looks good. Everything looks good. I'm going to go to checkout. Now, I have a deposit account with them, so I will just use that. But if you want to put in your credit card info, you click here. But I will say pay with the deposit account. And then over here, it's little tiny. See, it says pay. So pay. The information, we say okay. Click the continue button to complete your registration. You're not done yet. Continue. Here's where you submit your works. You have to upload a copy of your works. Okay. So we're going to upload two things. The first is a zip file of all the works. And if you're doing paintings, if you're doing whatever, you can upload them individually. If you're doing photographs, you have to use a zip file. Okay. Or they really strongly recommend it. You don't absolutely have to. But you also have to remember to upload the Excel spreadsheet. So I'm going to select the files to upload. And I have made a zip file even with removing number 33. And I am going to call this zip file the same as I called the other one. Okay. So now I'm going to select the files to upload. And right here on the desktop, I have something called to register. And I'm going to upload this zip file right here. Let's say open, right? I'm also going to, you could do this at the same time. I'm going to upload the Excel spreadsheet. Okay. And then I'm going to start upload. Now the Excel spreadsheet went really fast. I have to verify this thing. Yes, start upload. It's going. It's going slow, but it's going. When this is finished uploading, you click here to complete. And we're going to come back and do that in a minute. Okay. This one will take a second. So now let's answer some questions, and then we're going to do another registration if you have time, which is not photography. It's going to be the actual manuscript. And we're going to talk about why the thing that Michael gave me is uniquely complicated in the whole annals of copyright law. Okay, so let me stop.
Again, I want to make it real.
Yeah, you did a good job. So I'm going to stop here and let's answer some questions. Now, okay. So the screen share should be full screen here. You should be able to see that full screen. I was looking at one of the messages in chat. You can also make just adjust your browser window, which will change the size of all that stuff. So hopefully that will help that. So let's go down and look at questions. So Angela asks, what if you uploaded your work to your art website, but then took it down? Let me change that back. But then took it down and it has been offline for over a year. Is that work still considered published? So the Copyright Office talks about first publication. And once something is published, it's either published or not published. If it would have been determined to be published at the time you uploaded it, it doesn't matter that you then took it down. It would still be a published work. That is my short answer there. And Michael, jump in if I say something you disagree with.
I agree with that completely.
The next question, D asks, if I register published and unpublished photographs on the same application by mistake, what are the ramifications? Super intricate question that I literally was just writing on this morning. The bottom line is that you can do what's known as a supplementary registration, where you pull out the published works and you would resubmit those, but the underlying application that you originally did can be left with a supplement. So there's one part of it you have to cancel and resubmit, and the other part of it that you just have to supplement. Why is this so tricky? It's tricky because you have different legal rights for published and unpublished images. And if you ever want to enforce those rights, the very first thing a lawyer is going to look at on the other side is to say, hey, these you commingled, published and unpublished, therefore the whole registration is invalid. You want to get in front of that by making sure that you separate out published and unpublished. Here's where it gets a little trickier, okay? If you filed this application 20, 30 years ago, you definitely want to check with a lawyer, because before the online application process, there were some different rules related to this, and it can get pretty intricate. But if you filed something essentially in the last 10 years and you mix published and unpublished, you want to think about how to separate those out. Again, the copyright application process is meant to be able to be done by you without a lawyer. But if you run into an issue like that, you may want to give someone a call. That gets a little sticky. I probably have spent 100 hours reading the Copyright Office compendium in the last month, and that is all about the rules for this stuff. In fact, if you're really curious, chapter 1800 of the Copyright Office compendium is about post-registration procedures, and then you can figure out how to do supplementary registrations. Good question. How long does it take typically to get a copyright registration? So it says somewhere between 6 and 12 months usually. I've had them come back in a month. I've had them come back in 15 months. They're suffering just like everyone else from the pandemic. All the examiners are working from home. I haven't been able to tell yet if that's negatively affected processing times, because we're still waiting for ones that were processed before the pandemic, right? I have a feeling it might. So the short answer is a long time. Now, if you upload your pictures the way that we did here, all electronically, you're good to go. There is an option where you can mail in your work as a deposit copy. If you mail in your work, it takes longer. The only time I've done that is with certain books where we might not have a manuscript that encompasses the copyrightable aspects that I'm particularly interested in. Okay, so do you need the Excel spreadsheet for works other than photographs? No, that's a photo-specific thing, and it only came about a month ago, or a year ago, year and a half ago. Do all photographs in a group need to be the same year? Okay, if you have a group of photographs and those photographs are published, they all have to be published in the same year. Not taken, but published in the same year. So if I was on a photo shoot on December 31st and it went into January 1, I have to file 2 separate applications that for published photographs, what I took on one day versus another. If your work is unpublished, nowhere on the spreadsheet did you see a place where I had to list the date of publication, right? Now it says, in the, when we were doing it, it says, when were these works created, right? And so if you go back, everything's uploaded, I just clicked the big green button that said submit. We're done. It's now submitted. Good to go. Michael, good to go on that. Okay. It is not a requirement that unpublished works are done in the same year. But I want to look up exactly what the Copyright Office. Hold on one second. I'm going to go ahead. Oh, you can still see some of that. Let me go and show you exactly where I'm looking to give you the answer for that. If I go, sorry, one second. I'll make this bigger so everyone can see it. If I go here and let's say I'm doing a group of photographs and it is unpublished photographs, right? I'm going to start registration, unpublished photographs. Notice it says all the photographs have to do these things, okay? I'm going to go one step further so that you can see the field I was going to tell you about. For the moment, under titles, see it says year of completion right here. These help boxes are actually helpful. It says the year of completion is the year in which the author shot the most recent photograph in the group. So to answer your question, no, they don't. If it's unpublished photographs, they don't all have to be in the same year, and the year of completion is the most recent photograph in the group. Good question.
Okay. So did you show us where you got that spreadsheet? Was that on the website as well?
Oh, yes. Yes, let me show you that real quick. So here, if I go, I'm going to actually share the whole application window of Chrome. And now, the easiest way to go about doing this is, I'm actually going to hit cancel there. The type of group. On this page where it says type of group, it says the list should be submitted in this. You're strongly encouraged to use the title template. By clicking here, you get the document and it just downloaded here, you can see in the bottom. So you click just there and you'll get the document. Good question. I think we have one or two more, and then we're going to do the second registration, which is going to be quicker than the first. Okay. How should one approach the registering of an archive of 30 or 40 years of professional and fine art photographs, also assuming variations within each actual shoot or project? So that's a question I get a lot. I work with a lot of photographers. What I say is this: establish your system so that from this day forward, everything is registered, so you're always getting your new work. And then start looking at, you mentioned a book publication project. If you know what's going to end up in the book, you can register those things that you know. If you're trying to register your whole archive, I recommend kind of a two-pronged approach. One is your superstar images that for the last 30 or 40 years, everyone knows about, right? Start registering those because those are the most likely to be infringed. Then work backwards by year. And remember, you always have to keep in mind published versus unpublished work. You can do a lot of unpublished, but you need to be very clear that if you only had one photograph published in a year, or that would be considered published, and the previous year, you know, has 500, then you can't put those on the same application. For published works, published groups of photographs, you have to have separate applications. So that's kind of my approach to it. Okay. A follow-up question for photographers with large archives: is it okay to register only several photos for each session or project in order to maximize the cap of 750 images? Yeah, so you can, back in the day, this whole 750 image cap was a recent development. We used to be able to register as many unpublished images as we wanted. I would come back and register 20, 30,000 images from, you know, spending a month in Alaska at a time on one application. That was fine. But now we're limited to 750. So you have to be a little more selective if you're trying to register a lot of stuff. You do not have to register everything. In fact, remember, registration is all about having a remedy if you are infringed. If you have outtakes and things that will never be used in any, you know, you have some that have the lens cap on and everything else, obviously don't register those. By the way, I just registered everything back when we could register as many as we wanted. If it was out of focus, if it was, you know, the wrong direction, whatever, that was okay then. Now, much more selective in registrations. Good question. So, question here from Jenny. If you want to submit your copyright application but then want to publish your work to sell online, is it safe to do so before your application is completed by the Copyright Office? So actually, a year ago, I would have had a very definitive answer, and it's the same answer I'm going to give you now with one little caveat. Yes, because when you file your copyright application, you're attesting that at the time of your application, these images are unpublished, and later on, you're going to publish them. You do not need to re-register your work when it's published. Once you file your registration, you're good to go. You have your unpublished work, you later on publish it, fine. You don't have to supplement, you don't have to tell anyone, you're protected. Now, there is, this actually goes to a question that is real interesting that I've given some thought to, but not a ton, and I don't know what Michael will think. But there was a Supreme Court case that said you cannot go to court until you have your copyright application, your certificate. It's been officially registered. But let's say that takes 8 months, and you register as unpublished, you don't have your certificate, you then publish and you are infringed, and you can't go to court till you get your certificate. But when you get your certificate, it says unpublished, right? And that should be fine if you can wait. But what if in the middle you go back to re-register with special handling, but now your work has been published? And so this is a really narrow set of circumstances that could ever exist. My bottom line to you, so that we don't get too far in the weeds, is that yes, you should be just fine. If you register as unpublished when they were unpublished, and then later on you publish and you're infringed, while you're waiting for your certificate, you are protected. With the only caveat that if you're involved in immediate litigation, it might be a touch different. And I don't want to muddy the waters. That's a very small subset of things that could happen. Okay. Oh, wow. Lots more questions. Okay.
Lots more.
I'm going to do one or two more, and then I'm going to hop back in and do the other registration real quickly. And Michael, while I'm finishing up these questions, I will explain why a book of poetry is unique. If you want the entire book copyrighted, then you can register it as a literary work. If you want each individual poem to be copyrighted, then you have to register it as a group of unpublished works, and so you only get 10. If you do the whole book, doesn't necessarily include each individual poem. That's a tricky answer. The Copyright Office has a specific page where they talk about how a book of poetry, just registering the book, does not register the individual component poems individually. It's an interesting situation, but what I would say in this situation is, since the book has poems and photographs and everything else, registering the whole thing as a literary work may be a good solution. But while I'm answering these questions, Mike, you let me know which way you think we should go, and I'll give you my 2 cents when we get there. Okay. Would a digital collage be considered a photograph, or can I choose to call it a photograph so it's easy to copyright a large set? The digital collages are all made digitally through applications like Photoshop. Well, I would look at a digital collage that is an entirely digital thing that's made in Photoshop. That's an interesting question. I would feel if each digital collage were considered a separate photograph, and that's how you were using them in the same way of a photograph, I think that would be okay.
As opposed to a print?
As opposed to a print, as opposed to a graphic design illustration, which is also made entirely in Photoshop, but would not be considered a photograph for purposes of registration. And I think that is where I'm getting hung up a minute. I'm not going to give an answer to this because I think that's a really interesting question. And so, Angela, know that we will look that answer up and I will email you, because that's a really interesting question. Because the first thing I think is it could be argued that that is a graphic design illustration, which then would require a separate type of application from a photograph.
I mean, it's very interesting because you can take a photograph and manipulate it so much that it's hardly to call it a photograph anymore. And so then what do you call that? So it's very interesting.
Yes, that's a good question, Angela. Good question. A follow-up, can you ballpark the date of publishing to the best of your ability? What if the publishing year is found to be wrong down the line? You can amend, as I was mentioning before, supplemental registrations, things that have been previously registered. You do want to get just as close as you can. This is a reason why I really recommend everyone register everything when it's unpublished. Michael said you have to register within before the infringement or within 3 months of first publication to get all your rights and remedies. Now, when I hear 3 months, what I think is 4 times a year. If you're only creating a certain subset of works, you still need to make the published-unpublished distinction, but you can group things in a way to minimize the number of applications you have to make, right? Because you get the protection whether something is unpublished or whether it's been published within, or whether it's been infringed within 3 months of first publication. Okay. Can you start an application and save it and go back to finish it? Absolutely. I may look at it and show you that in a minute. And last one I'm going to answer here. What if after the process of registering photographs, you change your file names? Do you keep a separate folder that contains the registration spreadsheet and image copies? How to keep track of all of this? I would, since we're doing this whole spreadsheet world now, I would just create a new folder that you have in there. You don't need to go change anything. You don't need to change file names with the Copyright Office. You don't need to do any of that. All those file names and titles are only for the registration process. You can certainly change those in the future. It probably is a good idea to save all the registration information each time you make an application. Doesn't take up any space on your screen. You would save the application and save the spreadsheet and then add in the certificate. Okay, let's go do one more. Boy, how are y'all doing? Is this good? So let me just, there are a few more questions in chat, some of which is actually easy to answer and very straightforward. What is the minimum size for images? So you have a maximum upload size of 500 megabytes for a zip file. Your images just have to be, quote, identifiable. And so identifiable means that pretty much just a thumbnail or bigger. But I always recommend about 1,000 pixels on the long side. You can use a compressed JPEG. And if you're doing this with artwork, you would take pictures from all around, all different sides of the artwork, right? Let's say a sculpture, you could do, 5 or 6 different images that all show your work for your deposit copy. But the reason I say 1,000 pixels on the long side for photographs is because if this ever goes to court, the lawyer's going to have to make an exhibit to show the jury. And if you have a little thumbnail there, that's not going to be as good as if you have a bigger one. That, again, very rare scenario, but I actually just dealt with that 2 weeks ago, that someone had thumbnails and the lawyer had a hard time figuring out what to do with it. Should I register my song, lyrics, or music video? Yes, you should register your song, but what does song mean? Well, song has 2 underlying categories. There are sound recordings and there are musical compositions. The composition is like the sheet music. The sound recording is the actual, the MP3 type thing. So every song has
the words.
The words, yeah. Yes, and then you have the words, right? Those can be different. Those are different copyrights. Now, the music video is a whole different thing. There's a whole category of motion pictures and videos that you would animate or that you would register. So for a music video, if you wrote the song and performed the song and you wrote the lyrics and the music and the video, you might have 4 or 5 different copyright applications to get that all squared away. Now, remember, you can use a group of unpublished works application to do an album. There's some rules to that, and I may click on that here in a second. Okay. Meg talks about that there's 100 years of images in the archive. Frankly, Meg, it sounds like you might be with an organization. give us a call. We do a lot of stuff like that for organizations. It's different for an individual. There's some things that we can do with organizations to really streamline the process. And when you're getting to dates and everything like that, there's some things that you can do when you're a company that you can't quite do when you're an individual. So I'm happy to talk about that. Lori, on Facebook, I show my process design painting stage. Does that mean my art is published as soon as I post anything? So there's a whole separate category of things that are works in progress and how that affects the world of copyright and your copyrights. I would say that no, whenever you post something that's a work in progress, I would clearly identify that it's a work in progress. And that this is not for sale and not for anything. You're not putting it out into the world for further distribution. You're simply showing something that will be created in the future. If you were really, really wanting to protect everything, the Copyright Office does have this unique thing called pre-registration, but it's expensive and almost never is what I'd recommend unless you are working in a very concrete area where you're being paid a lot in advance, and you want to make sure you have protection the very second that you publish something or that you finish something. Okay, so let's do one more quick application, and then we will go from there. Michael, any thoughts on what I mentioned earlier?
I think I want to do it as a single literary work, and I'd be happy to argue that each individual poem is protectable even under that, regardless of what they say on their website.
That is what we're going to do. And so there are two ways we can do this. There's over here, it says register one work by one author. I'm going to click on it because if I had one painting or one photograph to register, or one poem or one song, here it says, this application cannot be used to register a book of poetry. So I'm not going to use this application for that. Okay, I'm not going to use this application for that. But let's say you had one painting or one photograph. Use this one. It only costs $35 for one thing. Okay. Now, I am going to use the standard application for what we're talking about. And it is used to register one work. And then it talks about all these various things. We've gone over most of these, so I'm going to start registration. Now, type of work, literary work. And now it starts talking about all these various things. Literary works include fiction, nonfiction, poetry, textbooks. You selected the standard application, one work. 10 unpublished works on the same application. That's the form we used, I showed you earlier. That's not what we're using here. This is one work that we are doing. So I'm going to click check and continue. Now, by the way, I told you I'd show you where the case number is at the top of each page right here. There's your case number right there at the top. So we're going to give this a title, the title type, title of work being registered, correct?
Yes.
Yeah, Michael? Okay.
Ignorant Eyes.
Okay, great. Ignorant Eyes. Okay, good. Okay, we'll say save. This is exactly where it gave me a hard time last time. There we go. Perfect. Now we'll say continue. Is it published or unpublished? We'll say no, it has not been published. Okay. Year of completion, 2020, right?
Yes.
Perfect. Continue. Who is the author? Well, guess what? We're going to talk about Michael again. Is it a work made for hire? We're going to say no, it's not. United States, United States. Now notice the first time it took us 45 minutes to go through it. The rest of the time it is going to take very quick. It's going to be very quick. Did you create the text?
Yes.
Yes. Did you create the photographs?
Yes.
So I'm going to click help for a second. And then it says you can select the text, the computer program, the photographs, and the artwork, which would include drawings or non-photographic pictorial representations. Okay. Whatever the case is. Photographs, is there any artwork?
Not beyond the photographs.
Great. So we'll say save. Now, are these all the authors? Yes, those are all the authors. So now I say continue. And again, we're working down the checklist box on the left-hand side, okay? Who is the claimant? New claimant. Oh, there we go. Perfect. Save. These are exactly the same fields that we filled out before. I have my claimant down here. I now say continue. Limitations of claim. This is a little different, and this is where if you are using something where you need to disclaim certain works, then you would do that here. For example, if I took photographs that were in Michael's work, this book he's registering, he could say that he's excluding certain photographs, and this is where I would put in my registration numbers and stuff, or because it's material not owned by the claimant. You would also do this if you have work from the public domain that's in there, previously registered material, previously published material, right? That kind of thing. Actually, previously published material is interesting in the case that we're talking about, but I actually have a solution for that that would take longer than this. So we're just going to register this, and then I'm going to show you, Michael, what we'll do with that one picture later. Okay, so I'm not going to click anything on limitation of claim. Rights and permission. Let's see, copy. There we go. Continue. Who's the correspondent? Hey. Where should we mail the certificate? All right. I think we all know at this point. Oh, I clicked the wrong thing. No big deal. There we go. I don't want to take your survey right now. You're making me type in too many things. Okay, any special handling? No, right? We all know what special handling is now. It's where you pay an extra $800. Okay, I certify that I am the authorized agent. Of course, if you did this, you would certify that you're either the author or copyright claimant or the owner of exclusive rights. Put in my name. Great. Continue. All right, that all looks good. I feel like we did it the right way. If I make a mistake, if I mess up an address or something, I can go back and fix it using what I've talked about a few times. I don't think I made a mistake. I will add to cart. I will check out. At this point, I will pay. The standard application is $65. The group of photographs or the group of unpublished works is $55. The single application is $35. I'm going to pay with my deposit account. Of course, you would put in your information up there if you wanted to. I will go ahead and click. Oh, no, I don't have money in the account. Okay, let's try again. What I'm going to do here, I'm going to go back. I'm going to change it so that we don't waste some more time. Add more services. I've now saved it in my working cases, right? And so I will go back and just upload the last thing, but that's how you do a copyright registration for a literary work using the standard application.
That answered somebody's question about can you save it and come back later? Yes.
Yes, you can save it and come back later. Okay, so I'm going to minimize this. And let's see if we have a few more questions. One question in chat. I may have missed this prior, but what are all the benefits of copyrighting visual artworks in the long run? The benefits primarily are your ability to enforce your copyrights if you're ever infringed. Those can include up to $150,000 per infringement in court. Those also, you can get attorney's fees, which is the big one, because without that, it's very hard to find attorneys who will take on the various cases. You really want, if I could do one thing to get all artists, if I could make artists do one thing, it's register their copyrights. Register your copyrights, just register your copyrights. If you are ever infringed, you will be real happy you did. I talk to people every month who, had they registered their copyrights properly, might have been able to get their work protected, might have been eligible for millions of dollars in infringement fees, but just didn't register their work. So definitely please do that. Okay, questions. Oh, we got a lot. Okay, let's see. Let's see where I stopped. Digital collage, ballpark, registering photographs. What if you're, oh, good question. What if you're registered as a sole proprietorship or an LLC? Can you then register like an organization? So you have to figure out, are you an employee of your organization? If you're an employee, like you have a corporation and you are listed as a W-2 employee, then you are, this is a work made for hire, unless you have a written statement to the contrary that you individually own your copyrights. There are business decisions why you might want to individually own them, or you might want your copyrights to be assets of the organization. But realize that even if you are a single owner of a S Corp and you are literally the only person listed as an employee, it could be argued that that is a work made for hire situation, and therefore you shouldn't fill it out in your name, but in the name of the business. Again, just today, I wrote a whole piece in a case that I'm giving a deposition in tomorrow about some of these issues, the work made for hire issue in particular. Interesting question. What if one of your poems is accepted in a publication, but you haven't copyrighted the poem yet? Can you do it before it's published? Would the publication have any rights over the work? No, the publication would not have rights over the work, but if you have put it out in the world so that someone is going to publish it, the question is that now published even if they haven't actually printed it? I might argue that it is, but remember, you have 3 months from first publication to register your work as published, and then you have all the protections that you would have anyway. So go register that work. Stick it on a single, the single application for $35. Register the one poem that you know is going out into the world, and register it as published work, and you'll be protected no matter what. But the underlying question, does the magazine or periodical have any rights over the work? No. By submitting it, they have the limited right to display it and distribute it, yeah. But they don't have any of the other underlying copyright rights. Can I upload a decent resolution contact sheet in which all frames are visible as a single image in order to get more photo material outtakes and do a single registration? So no, this is something that people have tried, and different courts have found different ways, but almost uniformly the Copyright Office does not like that. I would strongly recommend against it, even though if you do that today, your copyright's not going to get rejected. This isn't like a trademark or a patent. They look at it, but they don't really look at it. They just look at it to make sure that you filled out the various fields. They don't look at the work to evaluate it in that kind of way. So the only time you would know that didn't work is if you had trouble. And then they say, well, let's look at the deposit copies. And then they say, well, this shouldn't have been registered in this way. If you register it where a contact sheet is your photograph, essentially what you're saying is, for someone to infringe on this copyright, then they have to be infringing on the entire set of images. But there's arguments that Michael and I could both make about, maybe image 4 is the heart of the work, and so therefore it would be a copyright. But I would not do that. That's frowned upon, if not completely out of your hands if the Copyright Office looked at it. All right. Well, we went a long time today. I hope you all got a lot of good information from that. If you have more questions about copyright, you can come to our legal clinic next week, where you can talk with me or Michael or one of my attorneys about this type of stuff. And we'd love to answer those questions. I appreciate you being patient and spending the time with us, and I hope you all learned something. Remember, this will be available for viewing after the fact as well. So thank you all. Adrian, do you have any final thoughts? Oh, you're muted. Oh, still muted.
Hey, how's that?
There you go. Good. Good.
I was just going to share our website for you to sign up for the legal clinic, or also register for the artist grants webinar and check out our auction, all that jazz. So cedarsunion.org is right up there for you. Thank you both. That was great, as always.
Awesome. Thank you. We'll see y'all next month, if not at the legal clinic next week. Bye.
Goodbye.